Judge, Mr. Estrada was kind enough to let me know that somehow they said he was exposed to COVID, so I got him a mask. That's why he's wearing a mask. I don't know if it's true or not, but anyway, that's why.
All right, so we were scheduled for jury trial. Where are we?
Judge, you made an offer. I've thoroughly discussed the offer with Mr. Estrada. I've explained the consequences of not taking the offer and that the court will not take any agreement. It will just be an open plea in court. I passed on the offer, and I'll be real blunt. I've given him ojos that if he gets a lot higher, it's on him, not me, and I'm not going to feel guilty. He said that he wants a trial, so I'm passing it on to the court to get it.
All right, Ms. Ferguson, I need a jury trial date for this. As criminal trial division, I need it as early as possible. All right, you're coming back for jury trial on February 6th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll need to plead open to the court. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and do a clothing exchange. If there's an issue with the clothing exchange, let the court know.
Judge, I appreciate it. Thank you for letting me come in today rather than Tuesday. And I'm still going to bet with you on the fact that they're going to cancel court that
You think they're going to cancel the court on that date?
It's not that I would, but you notice certain things like the sun rising.
All right, guys, buckle up. This courtroom scene kicks off with unexpected tension. What starts as a casual note about a CO mask quickly turns serious as the judge addresses a rejected plea deal. The defendant chooses trial over a safer option, raising the stakes immediately. Instead of accepting the offer, he decides to take his chances before a jury, knowing the potential consequences could be far more severe. You can already sense this won't be a routine hearing. The courtroom atmosphere shifts as the judge sets a firm trial date and makes it clear there will be no easy way back. This is where the pressure begins to build.
Hey, can we put him in the box? Counsel, can you let him see the evidence? And if you want another attorney for your jury trial, they need to be ready for trial on February 6th. You understand?
No.
And Judge, just be clear, I don't care one way or another, but if you are going to put someone else on the case, please let me know so I won't.
Oh, no, he's going to have if he wants another attorney, you'll have to hire that attorney. And that attorney needs to be excused. That attorney needs to be ready for jury trial on February 6th. And state, if you'll let him and counsel, if you'll stay so he can see the state trial.
There's another case, Mr. Estrada. He really, really doesn't like me, which is why I didn't want to do the discovery, told me to stop. I'm just telling you because I don't want to surprise you. I'm going to file motions to withdraw to protect myself.
Oh, I understand.
Okay.
Where is he? If you can come forward, sir. All right. So I want to let you know something. You came before the court and you said that you had not seen the state's file. I'm being told that you no longer want to see the state's file. So let me just tell you what's going to end up happening. You're going to go to trial, whether you've seen.
Here, the courtroom takes a sharp turn as the defendant challenges his own attorney, claiming that after years behind bars, he still hasn't had a proper chance to review the evidence against him. It's a surprising moment that raises serious questions about communication between the defendant and his legal counsel. The judge, however, refuses to let the case stall. Rather than allowing more delays, the court makes it clear that the trial will move forward as scheduled. Whether the defendant feels prepared or not, the expectation is clear. His day before the jury is coming, and there's no more time to waste.
Something that...
Oh, no, you said you've been incarcerated for 3 years.
Yes,
so how are you being rushed?
Exactly.
You're going to jury trial on February 6th.
I'm barely hearing anything about it just within these past couple months, man.
He was in another county, Judge.
I've been in another county, so this whole time I've been incarcerated, I haven't heard anything out of Bear
So
County.
let me ask you this. I want you to internalize what I'm saying. You were in custody in another county for what reason?
For ag robbery, allegedly.
So there you go. So this case is going to trial on February 6th. If you would like, I've given you the opportunity to sit in the box and read what the state has. What the state has in their file is what they have. I
understand that, Your Honor.
Here's the thing. The only thing about it, what's in the state's file are the names and police reports. Those people are not going to come in and let you talk to them right now because that's not what it is.
I understand what you're saying.
But you can look at the file. So you're coming back for jury trial on February 6th.
That's fine. Yes, ma'am.
All right. Thank you.
Thank you.
All right. How's everything going?
Pretty good, man.
All right. So how are you spending your time? What are you doing?
This segment takes the courtroom drama to another level. The defendant insists he's being rushed into trial, arguing that he hasn't had enough time to prepare. The judge quickly challenges that claim, pointing out that he's already been incarcerated for several years, making it difficult to justify any further delay. Then comes a major revelation. The defendant admits he had been in custody in another county on a separate robbery case. That single piece of information changes the entire context of the discussion. What initially sounded like a lack of preparation now appears to be part of a much larger legal history. With that clarification, the judge leaves no room for uncertainty. The trial will move forward as scheduled, reinforcing that the court expects the defendant to be ready regardless of the circumstances. The message is clear. The time for delays is past, and the case is heading to trial.
Review for the construction business, and I don't know if I'm gonna get a call this week or the next week, but maybe if I be able.
All right. Just 1 second. Excuse me. If you all can't whisper, then you're all going to have to confer outside. Daniel.
If I will be able try to look for another job, see if they do not contract me on.
All right. And so are you doing school or looking into school or anything of that nature?
Not right now. I'm looking just for a job right now.
Any type of trade school or
Also,
trade school or anything of that nature? What are you planning on doing with your future?
for a GED.
All right. So you said GED?
Mhm.
All right. Have you started working towards that?
So,
Say yes, ma'am, or no, ma'am. When she asks you a question.
not right now, man.
All right. So it's probably best if he starts trying to get his GED if he doesn't have it.
Yes, ma'am. That's what you're working on, correct? Trying to get your GED?
Mm-hmm.
Okay.
All right. So his GPS, what is the status of that? Is he on tracking or does he have scheduled
I
set
think
time?
he still has a full house GPS for the first 3 or 6 months.
Mhm.
And then after that, we're going to reevaluate, I believe, if I remember correctly.
All right. It's been 3 months.
Yes, ma'am. But I think it was 3 months, but I'm not sure. I don't want to lie to the court.
No. Because I think it's time.
The hearing then shifts to a different defendant, and the atmosphere becomes noticeably calmer. Instead of focusing on trial preparations, the judge turns attention to someone who is working to rebuild life after being released from custody. The conversation centers on employment, education, and long-term goals, reflecting a more supportive side of the justice system. As the discussion continues, the judge asks about job opportunities, school, and plans for earning a GED. These questions make it clear that the court's responsibility goes beyond imposing consequences. It also includes encouraging defendants to make meaningful progress and build a stable future. Even with the more encouraging tone, the expectations remain high. The defendant is being given an opportunity to prove they can stay on the right path, but that opportunity comes with accountability. It's a second chance, not a free pass, and the court makes it clear that continued progress will determine what happens next.
We have been in communication with him in regards to certain job fairs to go for. He's in compliance with all of his field visits, reporting on time.
So I think,
Judge, if we put him on track and he can go out and look for other jobs, he can stop at job sites and things
well,
like that.
I think what I'll start with, because now it's just partial, I'll start with him being allowed to do things in certain hours. So if it's not work related or if it's not for classes, I'll allow him to be out and about till 6 p.m.
Okay.
That means that you'll have to be at home at 6 p.m. Now, if you're at work and your work schedule takes you beyond 6 p.m., that's fine. So we'll start with that. And then the next time, if there are no issues, then we'll start with tracking only and then hopefully move towards removal.
So from what time to what time? I know from till 6 p.m., but what
We'll
time?
do it Monday through what date? Do you want Monday through Friday or Monday through Sunday?
Judge, we don't have any, I would say
Monday through Saturday.
All right. Monday through Saturday, we'll do 7 a.m. to 6 p.m.
6 a.m.
7 a.m. to 6
6
p.m.
a.m. to 6 p.m.
Okay, you want 6 a.m. to 6? Okay,
Yes, Judge.
she's
That
fighting for
way,
you.
just in case he gets a job to where he has to, you know.
All right, so your GPS now will be 6 a.m. to 6 p.m. That's whether you're looking for employment or whether you have a class or not. If you want to go to the park, then you can do that. So that's from 6 a.m. to 6 p.m. If there is something where you have employment and that employment takes you outside of that window or a class takes you outside of that window, let probation know.
Okay. I will notify them if it takes.
The hearing ends on a much more hopeful note than it began. A trusted friend and longtime supporter steps forward to help the defendant secure a job opportunity, demonstrating how the right guidance and community support can play a meaningful role in helping someone rebuild their life. It's a reminder that positive connections can sometimes make all the difference. Before concluding the case, the judge emphasizes the importance of communication, responsibility, and making the most of every opportunity. The message is clear. The court is willing to support those who are committed to changing their lives, but success depends on honesty, accountability, and consistent effort. The case closes with a sense of optimism, while also reinforcing that a second chance is only valuable if it's used wisely. Ultimately, the defendant's future will be shaped by the choices he makes from this point forward. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss another courtroom story. Thanks for watching, and we'll see you in the next one.
And then 3 more months, if there are no issues and nobody objects, it'll probably be removal.
Good. Just yesterday, it just happened that I got a call from an old client.
Mhm.
He owns a house framing business.
Mhm.
And he had some traffic tickets, so I went to pick up the money, pay the tickets. I'm gonna call him and see if he can use them.
Okay, awesome. Thank you. Johnny, you're so awesome.
Well,
I've known you forever. I've known you when I was a defense attorney and a prosecutor. You're just awesome.
well, thank you. So are you. It's
Oh.
fun. I love coming here.
Oh, thank you. So, Norma, on this case, if you can give me a date to come back in 3 months.
As far as the mental health treatment is concerned, are we okay just to monitor at this point? And if
Yes.
anything arises, let
Yes.
the court know?
We'll monitor. And if there are some issues that you're having, be sure to let your attorney know and let probation know, because we can't help you if we don't know.
Okay, ma'am.
And the last thing you want to happen is something that happened, and then you come back to this court and saying that you didn't tell anybody, because in this court, I believe that communication is key. When I place people on probation, I want them to be successful. So you have no excuse. And if the probation officer, who is your probation officer, is not addressing some issue you have, you can always call your attorney, or either you can always come to court.
Right, we'll do, ma'am.
All right. What?
April the 4th, Your Honor.
All right, Norma, we're going to call this back on April 4th.
First one.
Your Honor, may I approach?
Yes.
I called a friend of mine. He
Mhm.
doesn't need anybody, but I called another friend and he's gonna hire him.
Oh, awesome. Jenny, you're so awesome.
It's the biggest cabinet making company in San Antonio.
Oh, that is so great.
So I'm gonna take him to interview.
Wow. Oh.
And he said, if you recommend him, I'm gonna hire him. So I'm gonna take him. I can't today, but tomorrow I'll take him over there. And he's got a job.
Oh, that is so awesome.
Okay.
Thank you, Johnny.
Everyone to know.
Saving.
The hearing ends on a much more hopeful note than it began. A trusted friend and longtime supporter steps forward to help the defendant secure a job opportunity, demonstrating how the right guidance and community support can play a meaningful role in helping someone rebuild their life. It's a reminder that positive connections can sometimes make all the difference. Before concluding the case, the judge emphasizes the importance of communication, responsibility, and making the most of every opportunity. The message is clear. The court is willing to support those who are committed to changing their lives, but success depends on honesty, accountability, and consistent effort. The case closes with a sense of optimism, while also reinforcing that a second chance is only valuable if it's used wisely. Ultimately, the defendant's future will be shaped by the choices he makes from this point forward. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss another courtroom story. Thanks for watching, and we'll see you in the next one.